Well, good afternoon, everybody. Thank you for coming to join our presentation on navigating collective bargaining and collective agreements. Thank you for joining in. Great to see you, and I hope you enjoy the next hour as we talk through some of the important considerations for collective bargaining. So in terms of what we will cover today, there are a few key considerations. The employment jurisdiction, as you probably will have discerned, is going through many changes at present, and that includes changes to collective bargaining and pay equity. So it's now more important than ever to understand what those changes are, at least in a collective bargaining context, and how they may impact on your organisation. Today I'm going to be focusing on collective bargaining and providing you with an opportunity to refresh your knowledge and to learn about recent case law and some recent changes. We'll be walking through everything you need to know about collective bargaining to set you up for successful negotiations and hopefully the best outcome possible. We'll cover foundations of collective bargaining and your legal obligations. We'll cover the key clauses that should be included into your employment agreements and the pitfalls you need to be aware of. Some tips for effective good faith negotiation, some recent case law, and some detail on the recent pay equity changes. And we'll break down all of those key components. And my goal today is to ensure that you leave this session with a better understanding of collective bargaining and the law that sits around that. So let's start then with the foundations of collective bargaining and your obligations. In New Zealand, the foundations of collective bargaining and an employer's legal obligations are set out primarily in the Employment Relations Act 2000. And the cornerstone of all employment relationships really is the principle of good faith. And the principle of good faith is contained in Section 4 of the Employment Relations Act. And it means that employees, employers, and unions have to engage with each other in good faith. And that means not directly or indirectly doing anything that will mislead or deceive the other, or that is likely to deceive or mislead. And in practice, the practical reality is that this means that all parties must be active and constructive, and they must communicate honestly and openly. And the good faith obligation is not just a common law duty, it is a legal obligation, and that's why it's set out in statute. And we need to remind ourselves that if there is a deliberate, serious, and sustained breach of good faith, then an individual, a union, or a company can be subject to a penalty in the Employment Relations Act for breaches of good faith.
Here's the audio.
Yeah, there are. Oh, we've got someone who's not on mute. If you could please pop your teams onto mute. Thank you. So in Part 5 of the Employment Relations Act, there's quite a few sections that deal directly with good faith bargaining, and they cover things like good faith, facilitating bargaining, breaches of good faith in the context of bargaining, collective agreements, undermining collective agreements in bargaining. And I'm going to discuss a small selection of some of those sections as it relates to collective bargaining. But one of the things I would say is that the legislation.govt.nz website contains a copy of the Employment Relations Act, and I'd strongly encourage you to reference that and, if need be, download and print it, because it is a really important resource to use when you're considering collective bargaining, and the sections themselves should be your first point of recourse, rather than any commentary, which can often add complicated meaning. Starting then with Section 32 of the Employment Relations Act, it requires a union and an employer involved in bargaining to do several things. I would encourage you to also Google the Code of Good Faith for Bargaining. You can find that on the MB website. And since its passage in 2000, the Employment Relations Act has required the development of a Code of Good Faith for Bargaining and regular reviews of that. Largely, it has kept its core provisions since 2000, and for those of you who've been involved in this area for some time, you may recall Walter Grills. He was a MB mediator, and prior to that, an adjudicator under the Employment Contracts Act. He developed that initial Code of Good Faith, and it is a very useful document for helping you understand any problems that occur with bargaining and informing the provisions that you should put into a bargaining process agreement. Because the very first portion of Section 32 says that the employer and a union must use their best endeavours to enter into an arrangement as soon as possible after initiation of bargaining that sets out the process for conduct of the bargaining itself. I often say that that section requires the parties to agree on how they're going to agree before they agree. A bargaining process agreement is an unusual requirement in that it has no contractual status, but the courts have said that the best endeavours test, as referred to in subsection 1, means more than good faith. So it puts a high onus on the parties to reach agreement on the terms of a bargaining process agreement. Frequently, you will see unions say, well, we've tried, let's just carry on with the bargaining without one. My advice to you is that that's insufficient. The test of best endeavours requires more than that, and it is important that you agree a bargaining process agreement before you get into the bargaining proper. Things that should be covered in that bargaining process agreement are covered in the remainder of Section 32 and include things like detailing when you're going to meet each other, during what times, on what dates and where. It should include a statement to the extent that the parties aren't required to consider and respond to proposals that they all have already responded to. And it should also include a provision that says parties must consider and respond to proposals made by each other. All too often, I find that unions just simply say that's unacceptable when you put an employer claim.
I'll show you this real super quick.
Sorry, again, we've got someone who's on,
so you can
who's not on mute. Can we please ask that person to change their Teams to mute? Thank you. All too often, I see unions provide, responses to employer claims that says no, not accepted, but they do not explain why. They are required to do so, and don't be afraid to require them to do so. You can cite Section 32 of the Act as the basis for that obligation. Both parties must recognise the role and authority of the advocates and representatives of both sides. I find it amusing that in almost all of the bargaining that I'm involved in, unions will communicate directly with the client that I'm representing. That is a direct breach of Section 32. yet I don't tend to take a great deal of issue with it, because I think it's important for a union and an employer to have a relationship long after the collective has been bargained and I've left the table. But unions are equally quick to raise concerns if a representative such as myself were to communicate directly with their members. Having said that, once a union has communicated directly with my client, I feel somewhat emboldened to do the same afterwards, and that can be a useful tactic to bear in mind. Your bargaining process should also note that even though you might have come to a standstill on one particular issue, you've got to continue to bargain. And you can't do anything that would undermine or do anything that's likely to undermine the bargaining or the authority of the other party in the bargaining. And you must not bargain directly about terms and conditions of employment for a particular part of the collective agreement directly with the employees concerned. If there is a request for information in accordance with Section 34, and the employer believes that that information is commercially sensitive, then you must agree on the appointment of an independent reviewer. I say that your bargaining process agreement should include who that independent reviewer might be and who pays the cost. Typically, in my bargaining process agreements, I would require the person requesting the information, the party requesting the information, to be the party responsible for the cost, because in reality, it would be rare that a union would have commercially sensitive information relevant to the bargaining. I frequently will look on the Incorporated Society's website for information about particular unions, specifically their rules, because that's relevant for the number of delegates that an employer might like to recognise at the bargaining table and record in the bargaining process agreement. And I also look at their financials to see what sort of financial position the union is, because that's relevant when it comes to claims further down the track. So all in all, I think it's important to understand that the bargaining process agreement is an important tool for the purposes of bargaining, and that you must use your best endeavours to reach agreement about a bargaining process agreement before you move on to the bargaining proper. We then have Section 34 of the Employment Relations Act, and I just touched on this before. This section is all about the request of information from another. So either party is entitled to request information from the other in support of a claim that they are making at bargaining. If you wish to make one of these requests, it must be given in writing. It has to specify the nature of the information being requested in sufficient detail to enable the information being requested to be identified. And it must specify the claim or the response to a claim in respect of which the information is being requested. It's got to specify a reasonable time frame within which the information is to be provided, and then it falls to the party from whom the information has been requested to indicate whether or not they consider that the information in question should be treated as being confidential. If it is asserted that the information is confidential, then it is up to the parties to appoint an independent reviewer. If this hasn't been established in your bargaining process agreement, then the parties need to try and reach agreement about who the independent reviewer might be. typically, a union would propose a mediator from MB would be the independent reviewer. I have reservations about that because typically it is financial information that is being sought, and not all mediators at MB have the kind of commercial knowledge required to appropriately discern whether or not a request, for example, for a balance sheet or a profit and loss is commercially sensitive, in which case you're more likely wanting to direct that type of request to, say, a chartered accountant. If you can't agree on who the independent reviewer might be, then there is no obvious pointer in the section to who could resolve that dispute, and more likely that is something that the parties would direct to mediation. You then have your independent reviewer undertake the work, and they will determine whether or not the requested information is confidential, and they will make a decision on whether the information should be shared, and if so, on what parameters. There can be several obligations on the party receiving information during the bargaining process, and they include using the information only for the purposes of the bargaining, treating that information as confidential, and not disclosing the information, including to employees being bound by the collective agreement being bargained for. At present, I am involved in some bargaining, with ETU. The bargaining concerned is, on my side at least, seeking to significantly pare back the entitlements that exist within the collective employment agreement with the employer. And the reason the employer is proposing to do this is because the consequence of the bargaining over the years has positioned that employer such that it is uncompetitive when tendering for work, because the cost of employment is substantially greater than the competitors. For example, there is allowances paid for all sorts of things. There's enhanced leave provisions. There's long service type payments, and payments made for reaching a certain wage grade. The employer has indicated to the union that if those changes were not made, the business is at risk of being closed, and unsurprisingly, the union has requested confidential information. At this point, the company has been prepared to share graphs and numbers detailing EBITDA and net profit and gross profit. I expect that we will get a formal information request from the union so that it can be checked by an independent reviewer and more detail sought. I guess important to note that there are some pitfalls around these types of requests for information, and they include that the Privacy Act still binds the employer and the information disclosed. So it's important to consider what the impacts of the Privacy Act might be on the requested information, and if whether providing that could impact on the company by way of a breach of the Privacy Act. Secondly, you can't decline a request if the Official Information Act is applicable to you as an employer. So it's important to understand those considerations as well. The next section in the Act is section 59A through to section 59C. And those sections are about undermining the collective bargaining or undermining an existing collective agreement that is in force. And these are both key issues that employers need to be aware of, because it can be an easy trap to fall into when an employee wishes to negotiate an individual agreement and include benefits that they have seen in a collective agreement. So passing on is where either during the bargaining or after the bargaining and once the collective agreement is in force, the employer passes on identical terms and conditions to non-union employees or indeed another union. And if an employer did pass on identical terms and conditions bargained in a collective to someone on an individual, it could be argued to amount to a breach of good faith under the Employment Relations Act. So when you're negotiating separate union agreements or individual agreements, it's important that you are aware of these obligations of not passing on and that you can comply with those. I don't intend to drill into these sections with a great deal of depth, but it is important to understand that the test for breaches of those sections is intention. The employer needed to have the intention to undermine the bargaining or the collective agreement, and the consequence was to have done so. Those tests are quite a high threshold and quite a high burden. And as a result, there are very few cases that exist where that has been proven. I guess what I would say is don't put yourself in a situation where you're vulnerable to that type of allegation. And if you're in the process of dealing with individuals post having negotiated terms with a union and concluded bargaining for a collective agreement, make sure that any terms that you pass on to individuals are obviously different to those which were provided for in the collective. So coming back and regrouping to the process is initiation of bargaining. Some of you who are familiar with this area will appreciate that a union can do that 60 days prior to the expiry of an existing collective if there is one, or at any time if there is not one, so long as they've got 2 or more members. And an employer can only initiate bargaining 30 days prior to the expiry of a collective agreement if there is already one, or at any time if that is what you would wanting to do. Once the initiation has occurred, there's an obligation on the employer to advise all employees who would be covered by the intended coverage of the collective agreement, regardless of whether they are union members or not. And that notice must be provided within 10 days of the initiation having occurred. And it must say who the intended parties to the bargaining are, what the intended coverage of the bargaining would be, and what the next steps for the bargaining are. Once that is done, then the parties need to agree terms for a bargaining process agreement. And as I touched on before, this should at a minimum include details of who the parties are, who the negotiating teams will be, including how many employee representatives the employer will acknowledge, because people expect to be paid for this bargaining. My general rule of thumb is 1 delegate per 100 employees, but that is something that needs to be negotiated and discussed in terms of the content of the bargaining process agreement. You need to include a provision in there on who has authority to reach agreement and how. That will normally include a ratification process for the union. The union's entitled to set its own ratification process, and an employer cannot dictate what that might be. You would include venues for the bargaining and dates, and often one of the most important things to union is who pays for the lunch, the morning and afternoon teas. And invariably that will be covered in your BPA. You need to include when and how claims will be exchanged between the parties, who's responsible for drafting up the new agreement, and how the parties will communicate with members. Frequently, unions will tell employers that they are not entitled to communicate with their own employees whilst bargaining is in force. That is not correct. They can. It is provided for in the Act, so make sure you address that in your bargaining process agreement. They can communicate with their own employees, but they can't then attempt to bargain about matters for the bargaining. They can provide updates, though, on offers they've made and statements that they have made during the bargaining. The next step is for each side to produce a claims paper. So typically that would involve a list of claims that explains the proposed changes to clauses within the collective agreement, accompanied by a tracked changes Word version of the collective agreement, setting out where the changes would apply and what the new changes would look like. And largely those two claims papers are negotiated as between the union and the employer as agreed per the terms of the bargaining process agreement, and then it is bargaining. So negotiations for a settled and existing collective agreement should really, in my view, only take a maximum of a day. Unfortunately, many, however, take several more days than that. And that being so, you might put in your bargaining process agreement that you will only agree to pay the staff delegates for a specified number of days to attend the bargaining. Otherwise, there is no incentive to reach agreement, and it just becomes a talk fest where people enjoy a nice lunch, morning and afternoon tea, and have a day off sitting listening to the bargaining occurring. I've got a client right now who's 7 separate days of bargaining in and still no closer to settlement of a new collective agreement. That's less than ideal. The last step in the process is ratification. So the employer bargaining team may or may not have authority at the table to agree to a proposal, or it might require approval by someone further up the chain. Could even go so far as the chief executive, and the union will take the tracked changes, collective agreement, and the terms of settlement back to their membership for ratification. And once ratification occurs, then the new collective agreement can be agreed and signed, and then once completed, it's behoven on one party. Again, this should be covered in your bargaining process agreement, to send a copy of the signed agreement to the Ministry of Business, Innovation and Employment so that they can keep track of their statistics about the collective agreement settled in New Zealand, the number of employees covered by them, and the key terms and conditions of employment. My tips would be make sure that you're really prepared and understand the issues of concern and the reasons behind your claims and are prepared to talk to those. You must act through as good faith, in good faith throughout the bargaining. So that means listening, not interrupting, actively remaining constructive, and so on. And note that if you don't reach agreement, the ultimate risk is that the Employment Relations Authority can do that for you. But that there are several steps to get there before you end up in that space, but there has been a case in New Zealand where that occurred. And excuse me, it's a very unpleasant place for an employer to be, where the terms and conditions of employer are set by an external third party. So some key clauses to watch out for. The Employment Relations Act says in clause 54 that all collective agreements must include a coverage clause. Coverage clauses, to me, are the most important clauses within a collective agreement as the law currently stands, because of the 30-day rule. The 30-day rule means that if a new person is employed and the role which they are being offered would fall within the coverage clause of the collective agreement, then they must be offered that collective agreement on an individual basis for the first 30 days of their employment. So that means that the employee has to then decide whether or not they will or won't join the union. That law is changing, and I will come to that shortly. But invariably, what that means is that people think the easiest thing to do is simply join the collective agreement, and before you know it, the majority of your staff are covered by a collective agreement, which means that in the event of strike action during collective bargaining, the union has a very strong mandate to compel change, because if they don't, then the business of the employer can be paused and customers disadvantaged. So I guess what I'm saying is pay special care to the coverage clause. Be aware of who your union members are and the roles that they perform, and confine the coverage strictly to the roles that are performed by your union members, rather than a blanket catch-all of everybody who might potentially walk through the door in the future. Your collective must have a clause dealing with the rates of salary or wages. They must have a clause about raising employment relationship problems, so that's disputes or personal grievance claims, and specify the timeframes for PG claims being 90 days, or in the case of sexual harassment, 12 months. It must have a clause about how the collective might be varied. I always insist on adding into the variation clause a date from when the variation will apply, because that ensures that there's no disputes into the future about when a particular change is applicable from. It must also have an expiry date, and it cannot contain anything that's contrary to law or inconsistent with the Employment Relations Act. Interestingly, in 2019, there was an amendment to the Employment Relations Act, and it said that the employers must do a few things around rates of pay. So what that said, and this was to combat conduct which I readily embraced before this change, which is where people can have a separate schedule that deals with rate of pay, notice period, and hours of work. You can still do all of that, but typically the collective agreement just simply said the rate of pay payable is that which is offered to an individual employee. That meant that there were no scales within a collective agreement for pay rates, and that then meant that it was less easy for individual employees to require a lift in salary to a new rate. You can still achieve that, but you must have a rate of pay or salary payable for a certain type of work or for a certain type of employee. So you can just simply put in, for example, if it's a fitter welder, the minimum pay rate might be X. You've also got to include minimum wages or salary payable for certain types of work for certain employees. You've got to include a method for calculating rates or minimum rates, and indicate how the rate may increase over the term of the agreement. It may, of course, not increase over the term of the agreement, so that's important to also understand. If it does increase over the term of the agreement, that's usually where the term of the agreement is greater than 1 year. Some other helpful clauses that you might like to think about is, when is overtime triggered? There is still considerable confusion over overtime and what it means. People typically think just because the word overtime is used, then a rate better than ordinary pay rates must be used. That's not the case. You can still have overtime payable at ordinary rates, and it's important to understand that. You might include additional benefits that you offer, things like service leave or special leave. You should deal with KiwiSaver, and whether that is a total remuneration approach or paid on top of someone's basic rate of pay. And you should also address any allowances that might be paid for things such as uniform, for work and travel away from home, and things like tools and that kind of thing. It's also really important to understand that passing on identical terms can be a breach of good faith if, as I said before, it's intended to undermine the bargaining or the collective and had the purpose of undermining the bargaining or the collective. Once something exists in a collective agreement, you can only change it by agreement, and that's where you might use a buyout, where you'll give a one-off payment to people to take away an advantage, or you might grandparent it in such a way that only people employed before a certain date will continue to enjoy a benefit. And it's also important to recognise that you shouldn't put anything that would more properly be treated as a policy matter into a collective, because it then needs to be bargained about. If it sits outside a collective and is truly a policy, then you only need to consult. Consultation doesn't require agreement, bargaining does. I said I'd talk about the 30-day rule. So at present, as I've said, Section 62 of the Act requires that any employee who joins an organisation who is not a union member and whose role would be covered by the coverage clause of the collective agreement must be covered by that collective agreement for the first 30 days of their employment, regardless of whether they are a union member or not. And it's only after the first 30 days of employment can an employer offer someone an individual employment agreement to sign. Now, the government has announced its intention to remove that 30-day rule. And I think that that's a really significant change, because the 30-day rule has been tweaked with but never removed in the 25 years that the Act has been in force. And what that will mean is that I think there'll be an impact on union membership, because people won't just by virtue of passage of time fall into union membership. What that then means is that you can now, in a collective sense, offer 90-day trial periods from the outset of employment. So right now, if someone is covered by a collective, you can't, and if you haven't got a 90-day trial bargained into your collective agreement, then even if they don't join the union and become covered by an individual employment agreement, you can't compel them to have a 90-day trial period, because they're not a new employee by the time you get to that. So this 30-day rule means that 90-day trial period clauses can be enforceable from day one for a new employee if they sign up on an individual. And if they don't, then they should be in the collective agreement anyway. But secondly, if you have an existing collective agreement right now that says for the first 30 days of employment, you'll be covered, blah, 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 you must, in your current bargaining, get that out. Because if you retain it in your a collective agreement and the government changes the law, then regardless of the law change, the better provision for the union contained within the collective that says you must be covered by the first 30 days applies. So if you are bargaining shortly before the end of the year, that should be a priority claim, not only to get a 90-day trial period into the collective agreement, but also to take out any reference to the 30-day rule. You'll get pushback from a union that'll say, no, it's in legislation, it needs to be in the collective. Your response will be, we can't contract out of the Act, so we don't need it in the collective. And I would make that a fundamental term of agreement so that you can get it out. The Minister for Workplace Relations, Brooke Van Velden, has said she will get it introduced by the end of the year. So I would strongly encourage you to get those clauses out of your collective agreements if you have them presently. So then I thought it might be helpful to talk about some tips for your collective bargaining. So you've got a bargaining process agreement in place by now, so you know what the steps are, but this is more about what is the how and how can you achieve some successful outcomes. If you've got a motive for doing something, then declare it from the get-go. be honest, engage in good faith, and say what your reasons are. So, for example, if it was me trying to get out the 30-day rule out of the collective, I would make it really clear that the government has signalled that there will be a legislation change by the end of the year. It will no longer be a requirement to offer those people that would fall within the coverage of the collective coverage under the collective for the first 30 days. So that clause needs to come out, because we don't want, as an employer, to be committed to an obligation that no longer exists at law. There'll be argument about to and fro about that, but that would be an example of what I'm meaning. We need to be honest and engage in good faith. You need to be prepared and make sure that you know what your claims say, what the impact of those are, and that you're also across the impacts of the claims that you're getting from the union. There's nothing worse than showing up to some bargaining and the employer is not prepared and isn't able to consider and respond to proposals made. The same applies with the union. Unfortunately, that is frequent, but that doesn't excuse a lack of preparation on an employer's side. You've got to be ready to respond to inquiries and correspondence as soon as possible, and keep those lines of communication open and professional. And remember the best endeavours tests for the BPA. Keep the meetings going. What you don't want to do is end up in strike action and or mediation, because the next step after that is facilitation, and if facilitation fails, then you're in the scenario where your terms and conditions of employment will be set by the ERA. I've said already that you do need to consider and respond to proposals made, and you've got to do it in a way that explains what your disagreement is and why you can't agree to what's being claimed. And we've already talked about undermining, and you shouldn't do that. But there's all sorts of things, tips and considerations you can have around not undermining bargaining. Don't forget the high threshold of the test. That isn't me saying, however, that you should go ahead and undermine. If in doubt, seek advice, because this is quite a complicated area. There have been some recent cases in this area that I thought that you might find interesting. And this first one is an Employment Relations Authority decision, but one which I found quite concerning. And it involved the what's known as MUNS, which is the Maritime Union of New Zealand, as well as the RMTU, which is the Rail and Maritime Transport Union. And there was a restructuring at Littleton Port Company, and both unions went to the employer and said, actually, we don't think that the employer has read the collective agreement properly, because we think that if you read the collective agreement, it says that the company will actually engage with us before they develop the restructuring proposal and excuse me, allow our input into the formal formulation of it. They said that the company had erred, the company had erred by presenting the unions with a proposal and said, give me your feedback. This matter was taken to the Employment Relations Authority, and the Employment Relations Authority said the collective agreement itself refers to cooperative and collaborative processes when considering significant operational changes. What the ERA did is it issued a compliance order saying that the port company needed to comply with the terms of the collective and stop direct consultation with the affected workers, go back to the drawing board, engage in structured consultation with both unions, and do so within 20 working days, so that the proposal that was then to be formally and finally formulated was one which was done in a collaborative way. What member Beck said in his determination on this issue was that LP Littleton Port Company needed to assist in reaching agreement and consensus on the organisational change because they needed to persuade the unions of the need to change and rebuild trust through constructive engagement. And what Member Beck also said is he found that the company should have developed their restructuring proposal with the unions prior to it being presented for formal consultation with all workers. And that was based, he said, on his views of the express provisions within the collective agreement about mutual good faith obligations. My message to you about that decision is, excuse me, is if you have any provisions in your collective agreement that say anything about what will happen as between the company and the unions when considering any changes within the business that include things like good faith and so on, you need to go back and revisit those provisions, see whether you might fall foul of them if you are trying to implement any sort of change in the business, and attempt to remedy those through changed bargaining. Otherwise, you risk not being able to restructure your business unless and until you first engage with the union on the formulation of a consultation proposal. Another decision was the Secretary for Education and the PSA, as they are commonly known. And the background to this was that there was a dispute over some redundancy and redeployment as a consequence of a restructuring in 2024. And there was a focus on the change management clauses in the collective agreement and how they were to be interpreted. And the key issues were whether or not the Ministry of Education had to agree with the PSA on surplus staff options or just consult and attempt to agree. And this went to the Employment Court, and the Employment Court said that the Ministry of Education had to reach agreement with the PSA on the redundancy options and negotiate individually with each employee and the PSA before any redundancy can occur, and that any redundancy cannot be imposed without both the union and employee agreement. So you can imagine what the implications of that would be for the Ministry of Education, because it basically severely and significantly limits the ministry's ability to unilaterally make staff redundant under the PSA's current collective. So it's important that you are alive to these types of clauses if they exist within your existing collective agreement, and consider whether they're fit for purpose or need to be changed. There was another decision in the authority in Donnelly and Fens, and in that decision there were some firefighters who were members of the union, and they sought some back pay under an old agreement back to 1992. The issue was that the collective agreement covered union members who were employed as of 1 July 2021, but the bargaining concluded in December 2022. And the Fens only paid back pay to employees who were still employed at the time of the ratification. And the 32 firefighters who brought this claim had left the employment of Fens before the collective agreement was satisfied. The court looked at the provisions of the Employment Relations Act and said that under Section 56 of the Act, only those people who are current employees at the time of the collective agreement being enforced can enforce those terms. And the prior agreement between Fens and the union confirmed that there was no pay to former back pay to former staff. So in that instance, there was no entitlement to the 32 claimants to back pay after they resigned, even if they'd worked for the period in which the back pay covers. Another decision, and this time it's the Chief of the New Zealand Defence Force and the PSA. And in this case, it involved an argument of unlawful pay preference for non-union staff during collective bargaining periods in 2020 and 2021. And Section 9 of the Employment Relations Act prohibits preference based on union or non-union membership. And the question raised by the PSA in this decision was whether or not the Defence Force breached that section by giving better or equal pay to non-union members. Was there an unlawful pass-on of union negotiated terms? And if so, what might the remedies be? The Employment Relations Authority found in the first instance that there was a breach of the preference prohibition by backdating and aligning pay for non-union staff, and that there was no breach of good faith that was so serious as to warrant penalties, but they did order back pay and interest to affected union members. This was appealed, and the Court of Appeal actually was asked by the Defence Force to reverse those findings. And the key points for discussion were whether or not those findings should be reversed. And the full court was convened and held that it not. I guess the key takeaway here is that you've got to be really careful about providing better pay outcomes to non-union staff during or after collective bargaining, because you risk breaching the Act. Excuse me, and it reinforces the importance of making sure that you behave in good faith when you are approaching bargaining. Another decision involves an applicant, Ms. Hart, who actually sued her union Meras for alleged good faith. So this union member alleged that she'd made misleading, deceptive and discrediting statements, and she sought actually compensatory damages and penalties against her union. And she also, in parallel to this, initiated a defamation claim in the district court against the individuals involved. And the question was whether or not the employment court had the power to award compensatory damages for a union's breach of good faith towards a member, or whether or not such a claim was excluded, leaving only penalty remedies or recourse in the ordinary courts for defamation. The court looked at good faith, Section 4, and remedies for breaches of good faith, which I talked about before, which is whether or not there is any remedy for a deliberate, serious and sustained breach of good faith. And they also looked at the jurisdiction that the employment relations has, which is founded entirely in statute. Basically, the court considered all of the arguments made, and it considered the statutory scheme and recent case law, especially a Supreme Court decision, and decided whether or not compensatory damages are available for a breach of good faith between a union and its member. And the court held that where there are no other potential remedies of a compensatory nature for breach of good faith duties, the court may consider exercising its jurisdiction under Section 189. But in this case, it didn't specifically order relief to Ms. Hart. But interesting, that was certainly a first for me to learn that an employee could bring as a member could bring a claim against its own union if it considered that the union had behaved in bad faith. Another decision, skipped a bit quickly there. Yes, sorry, I did. I skipped the Strauss decision in Fens, and in that case, there was a firefighter, Mr. Strauss, the union, and Fens that were all parties to the proceedings. And the dispute concerned Fens's disciplinary action against Strauss over his management of a mess allowance payment paid to firefighters for a shared kitchen, supplies and meals under the collective agreement. And the question was whether or not the employment court could award compensatory damages for a union's breach of good faith under the Act. And the authority had to decide whether or not FENS had a contractual right under the collective agreement to investigate and discipline an employee for a handling of that allowance. Oops, oh dear, sorry, I've bumped my screen. I'll just take that back. The authority, the result of that decision was that the authority found in favour of Strauss and the union, and that was that FENS did not have contractual authority under the collective agreement to investigate or discipline its employee for the handling of that allowance, and it issued a permanent injunction, meaning FENS was permanently restrained from taking disciplinary action against Mr. Strauss on this issue. And its reasoning was that there was a lack of clear policy and that the informal and widely accepted nature of the practice and management's awareness of it meant there was no basis for disciplinary action under the employment agreement. Again, this means that FENS was prevented from disciplining its own employee because it didn't have clear rules or policies around the application of a specific allowance. My tips, or the key takeaway there, is you need to make sure that any allowances that are payable under a collective agreement are clear, and that any policies that relate to the application of any term of a collective agreement are also clear, so as to enable an employer to take action if those rules are broken. Another decision is an airline pilot's decision involving Jetstar. And here the union brought a claim against Jetstar alleging breaches of Section 67G of the Act, which was about cancellation of shifts. And it was involving some Trans-Tasman pilots under a collective agreement. They were salaried, and their pay was unaffected by the number of shifts they worked in a roster period, but they could earn an extra flying allowance if they worked more than 65 hours per roster period. The rosters were published monthly, and they include various duties, flying, positioning, ground duties, standby days, and so on. And the shifts in the duties were changed due to operational disruptions. The question was whether or not the jurisdiction existed to require the company to provide a penalty for failing to provide reasonable period of notice for cancellation of shifts, and failing to provide reasonable compensation for cancelling shifts. In summary, the authority found that the pilots were considered shift workers under the Act, as their work occurs at different times of different days. The Section 67G requires employment agreements for shift workers to specify both a reasonable notice period for cancellation of shifts and reasonable compensation if that notice is not given. And it distinguished between a shift being varied due to operational need and cancelled, which is the focus of Section 67G. So only employer-initiated cancellations are relevant for 67G, not employee absences due to sick or personal reasons. So that case reinforces the importance of understanding whether or not the hours of work provision in your collective agreement constitutes a shift for the purposes of 67G of the Act, and making sure you understand your obligations then about reasonable notice and compensation for cancellation. Now, the final case is the Athletes Collective and High Performance Sport New Zealand. In summary, that case was about whether or not athletes paid by High Performance Sport New Zealand could be entitled to bargain collectively. The outcome was no, they were not. So lastly, just to cover the pay equity situation. So at the moment, the current process is basically that an employee or a union can raise a claim if the work is or was 60% predominantly female. and undervalued. There was a pretty low threshold. The claim only needed to be arguable, and the claims were often progressed without strong evidence of undervaluation. And the issues raised about this were that there was the low evidence requirements led to a lot of weak claims advancing, and employers were facing challenges in assessing claims validity and scope. So the changes that have been made by the government mean that the threshold is higher, so they must have merit. The percentage of domination of female workers is now raised to 70%, and it must be for at least 10 years. And the unions must show that the work is the same or substantially similar to another work predominantly dominated by males. So the impact on all of that is that the process now is more robust, and it helps employers better evaluate the scope. Yeah, that largely covers what I just talked about. So when it comes to pay equity settlements, the current process is that the settlements must include remuneration to resolve the pay equity issue, and must involve a pay equity review process. And the issues were that the short review cycles made it hard to tell if pay differences are due to renewed pay equity issues or short-term labour market changes. And that certainly, for example, would be the case with caregivers in rest homes, because as with any change to pay rates, relativities invariably also change at the same time. So that was one of the key issues of concern. The proposed changes are to remove the requirement and ability for settlements to include a review clause, and allow all claims to be raised 10 years after settlement if the new requirements are not met. And the intended impact is to provide a way to address new sex-based undervaluation over time without frequent disruptive reviews. So, what does that impact have on existing settled claims? Well, all existing pay equity claims that have been raised with an employer or lodged with the ERA or the court but not yet settled are now discontinued. The review clauses on all existing settlement agreements will become unenforceable, and new claims covering the work of a settled pay equity claim can't be raised for at least 10 years after the settlement date unless exceptional circumstances apply. And to proceed under the new regime, discontinued claims must be refiled and meet those stricter requirements. So then, is it time to review your existing collective agreement? I think so. And I've given you lots of reasons why I think that is the case. Alice, do we have any questions?
We do have one question. What happens if the collective expires and 12 months has passed, but you're still bargaining?
The collective agreement remains in force for a year after the bargaining. But beyond that, it applies as if it were an individual. So what that means is that if bargaining is not reached within those timeframes, then the 30-day rule doesn't apply. Is there any other questions, Alice?
No other questions.
Awesome. Well, thank you all very much for attending, and I hope that has been of some assistance. Thank you and goodbye.